tell you when to flip slides, okay?
Sounds good. I love being in control.
Okay, so this is patents versus trade secrets, and I am Luke Elbert. And bear with me here. We'll get through this. That's all right. Next slide here. So first, we're just going to go over the basics of patents. Really, the underlying theory is it's a limited monopoly. It encourages production of works in exchange for disclosure and enrichment of the public. There is the Patent Act, that is the law. I'm going to try and stay away from going too deep into the law here. And the subject matter really is a process, products, a manufactured item, or a composition of matter. But really, why do we have patents? It's an incentive to invent the invention. It's an incentive to disclose the invention to the public. What that allows is other people to see how to make this invention and then possibly make a better one in the future. And there's the incentive to commercialize the invention. All right, we can go to the next slide here.
Oops, let me try this again. There we go. Is that it, Luke?
Okay, that is it.
All right.
So next we have the trade secret basics here, and the underlying theory is just protection against unfair competition. There are both state.
You, Luke, just a moment. I have somebody waiting in the lobby. Matthew Travagelante. I don't know, Joe. Do you see that? Do you want to admit, Matthew?
Yeah. I'll handle that side of things.
Okay,
Thank
cool.
you.
No worries.
Okay. Once again, underlying theory, we just protect against unfair competition. There's both state and federal law regarding trade secrets, but the subject matter is anything that has commercial value for being unknown. I'll go into more specific examples a little bit down the road here, but really what this means is formulas, patterns, compilations, programs, devices, methods, a technique, or even a process. We can go ahead to the next slide. So kind of just looking here at patents versus trademarks side by side once again. The criteria for a patent is it must be new, useful, and non-obvious. The way you infringe a patent is by literal infringement or equivalence. But a major thing I want to point out is that what patents do is they grant investors a limited time monopoly on their idea. What it is it's a grant made by the government that in exchange for disclosing the invention confers upon the inventor the sole right to exclude others from making, selling, offering to sell, or importing that invention for a set period of time. The term length is 20 years from the filing date. A patent doesn't necessarily get approved right away, so it is 20 years from when you filed it. So you might only have about an actual time period of about 17 years of exclusivity if your patent takes 3 years to get approved. And next, we'll look at the bars to a patent. These are things that would prevent you from being able to patent your invention. These are public disclosures, sale or offered for a sale, or otherwise available to the public. The main reason for the bar of a patent is kind of just the general idea of you do not want to take away from the public of which it already has. So next, what we'll do is we're just going to look at trade secrets. Their criteria is it's not generally known. It has economic value, and there's a reasonable effort to maintain secrecy. The way you can infringe it is mainly through misappropriation, and that is basically through just acquiring the knowledge through an improper means. An advantage to this is the term length. As long as the information is kept secret and it's deriving some form of value, you can keep a trade secret forever. And we can we'll go through a few examples of that. But really, just to reiterate, trade secrets, it's really almost any business-related information that derives the independent economic value from not being generally known, and it's not readily ascertainable by proper means.
So guys, I'm going to interrupt just a minute. And sorry, Luke, you're doing a great job. So an example of a trade secret is the formula for Coke, right? You've already kind of figured that one out, right? Isn't that a beautiful
Correct.
thing? I mean, has anybody ever tasted an imitation Coke that really tasted like a Coke? I haven't. They're terrible. So it's a great thing to hold as a trade secret. Now, if you held that as a patent, if Coke had chosen to patent their formula, if they had chosen, they could have, right? Why not? They would have to have written that invention into a patent application and filed it, and that invention would teach the world to practice it. Okay? They would, in fact, have to enable another person to be able to repeat what they do, which means they could sell that Coke for 20 years and, in theory, have an exclusive market to it, but not in year 21, right? Okay, do you kind of see that? I just want to see the eyes and the nods. There's a real difference. So if you're going to patent it, and you could patent a formula for Coke, I think. I mean, why not? It's a beautiful thing. But you have a limited life now of that, of protecting someone else from practicing it. And if you patent it, you must tell somebody how to do it. You must. Okay? On the other hand, if you think you can keep it secret, you might be able to protect it for 100 years. Okay, that's it. That's it. Thanks. Keep going.
Sure, and just some other examples as well of trade secrets. You can have trade secrets and things that otherwise might not be patentable. This could be customer lists, market data, financial information, or something kind of along the lines of Coca-Cola. It could just be a food recipe. So if you can keep it secret, it'll be with you forever. We can go ahead and go to the next slide here.
Oops, I must put my cursor in the wrong spot here. There we go.
All right. So kind of looking at which is the better choice for a company. You really do have to just, keep these two important factors in mind. Is 20 years a sufficient period of protection, but also, during that period, is a competitor likely to reverse engineer or independently reproduce that product? We're going to go into reverse engineering, but independent reproducing is the same thing. Basically, if you acquired a product like a can of Coca-Cola, you went and bought it from a store, you acquired it in a proper means, you have all the rights to try and backstage it and create it yourself. But another thing I do want to point out here, just on this slide, is a patent. It only lasts for 20 years, but the protection is considerably stronger. But to reiterate what Professor Mosley was saying is you must disclose everything to the public. So had Coca-Cola patented it, they would have had to disclose the exact formula for making Coca-Cola, and then anyone could have made it 20 years down the road. A trade secret does not prevent another party from independently developing its own version of the product, process, or formula. So that's another thing to keep in mind, because just because they didn't get Coca-Cola necessarily right, it might be close enough. So Coca-Cola, if they saw, say Mr. Pibb, and they thought it was extremely close to, their brand Coca-Cola, they don't have any rights to enforce Pibb from stopping making their product, because they don't have the patent protection. They only have the trade secret. So the trade secrets do allow independent users to try and either mimic or create the exact product that you have. We'll go to the next slide here. So trade secrets, the benefits, and reverse engineering. Biggest benefit you're going to see is it is significantly less expensive. There's no cost in having a trade secret. Really, all you have to do is know you have a secret, try and keep it secret, and have a reasonable measure of secrecy. That can mean a lot of different things. I don't think we really have time to go into that, But on average, a patent's going to cost you about $10,000 to $20,000. It could be more expensive than that. So the big difference here is $10,000 to $20,000 or free. There's no filing or approval requirements for a trade secret. And once again, you just only thing it requires is just a reasonable effort to try and keep it a secret. So reverse engineering, is it legal? It is legal, and it really goes in. It can be illegal, but so long as you acquired a product by a proper means. So once again, to go to the Coca-Cola example, if I went and I bought a can of Coca-Cola, that's me acquiring it by a proper means. But I could go ahead and take that can of Coca-Cola and give it to the best scientist in the entire nation and say, hey, figure out the ingredients so I can make Coca-Cola myself. And that would be completely legal because I acquired it by a legal and proper means. So just reverse engineering is essentially you obtain a product by a fair and honest means, and then you work backwards to try and extrapolate the trade secret using only publicly available resources. Now, I wanted to go through this with you. I think hopefully I've done a decent enough job to where you guys can get this right. And I'm going to make sure you're not sleeping on me.
Good luck with that. I struggle every time I teach a class with that.
So kind of just looking at these two things side by side here, I want to just run down this slide with you guys and kind of see what you think. So looking at a can of Dr. Pepper, do you think that the invention would be useful beyond a 20-year patent life? I guess it's a little bit different. I thought we were going to be in person. So do we think it's useful? I believe yes. So it looks like so far it's favoring a trade secret. Is it easily reverse engineered? Kind of going along the lines of Coca-Cola. If I could take it to the best scientists in the world and they can't figure out the formula, it's not easily reverse engineered. Is the invention detectable in the final product? Because there's so many different ingredients in Dr. Pepper, and they have their hidden 23 ingredients. It's not easily detectable. So once again, it's favoring a trade secret. Is the invention embedded in the product? Is the invention embedded in the product and not obvious? For this one, I would say it doesn't really.
I mean, it's almost the reverse of the question before.
Yeah.
Yeah, it's if you had that product in your hand, you don't know how it's made. You know it tastes good, but you don't know how. Yeah, go ahead.
Okay, and then is it likely to be independently discovered soon? Once again, it really just goes down to those ingredients. The likelihood is of this one being discovered is no. So once again, this is going to favor the trade secret here. And then next we'll look at something as simple as a Post-it note. You might have thought, hey, maybe that's a trade secret. Maybe this could last forever. But kind of going down that same line right there, what you can see is it is obvious. It's just a glue that can be ripped off and stuck back on. Someone who is specialized in that field is easily going to be able to reproduce this. There's a chance that it would have been discovered on its own, easily reverse engineered. So what you're going to want to do at that standpoint is you're going to want to go for a patent, because at least you'll get that 20-year period of protection. And after that time, then people can go on and make different versions of your product. And we can go to the next slide here. So just questions to kind of ask before making a decision. Can a competitor independently come up with the same solution? I think that's a big one that kind of it goes to both patents and trade secrets. How long is your product life? Patents can be costly and time consuming. So if your product won't be commercially viable for a reasonable part of a 20-year time frame, a trade secret is probably the better option for you. What is the life what is your company? Where is your company in its life cycle? I'm sure that a lot of you being new entrepreneurs, you're going to be interested in starting startups or being a part of a startup. So it's important that you may need to weigh your IP protection against your cash flow considerations. If you don't have the cash flow, it might be better to try and go with the trade secret for the time. And really, you just have to see. I meant to get rid of this last one. I made an edit on it, but really, what will best serve your business priorities? And that really comes down to a lot of the times it's going to be financials. So if you're just starting out, if you think a trade secret is possible, it might be the best option for now. But kind of just through the whole presentation here, if it's a product that you think could easily be made or someone might think of it soon, then sometimes a patent may be your only option. And then if you guys have any questions for me, I would be more than willing to go ahead and answer them for you. Unless I did such a good job.
Yeah. You did a terrific job. Well, I'll throw one more example up just to, and Luke did a really good job. So, patents are restricted to certain categories of things, products, processes, articles of manufacture, and compositions of matter. Nothing more. Okay, that's it. Trade secrets can be just about anything if you can keep them secret and they have economic value by being unknown. And so I don't know why I was thinking about this morning, but suppose I'm a restaurant and I'm getting my sandwich bread in, and sometimes the bread gets stale and nobody likes it. And they send the sandwich back, but by mistake, when they sent me some bread, I put it in the freezer. I didn't mean to. Pulled it out after 15 minutes. Oh my gosh, this goes in the fridge, stick it in the fridge. But turns out that bread that's been in the freezer stays fresh forever. Like, it's crazy. And so now every time I get bread in, I stick it in the freezer for 15 minutes and I pull it out in the fridge. And people rave about this fresh bread. How do you keep your bread so fresh? Okay, now what do I do with that? Okay. Samuel, you're the only person I can see on screen. I see Wu Bender as well. Let me ask you a question. So I got this process, right? I just figured it out by mistake. I got perfect bread. Could I hold that as a trade secret? You can go ahead and unmute and speak if you like. Well, maybe not.
Yeah.
Okay. And it's pretty cool, isn't it? It's so simple and nobody knows it. As long as I keep it secret, I don't let the workers come in and see me take it and put it in the freezer and into the fridge, right? Okay, so that's an example. If I was to patent that, I'd have to patent it as a process. I don't know, maybe I could, but here again, the world would know. Okay, on the other hand, let's take another example and I'll pick on, is it Wu Bendy? That correct pronunciation? I'll tell you what, let me pick on Courtney. I can say your name, Courtney. Are you there? You can go ahead and unmute, Courtney.
Yes, hi.
Wonderful. All right, forgive me for picking on you. It's not Joe's fault. I did this on my own. Let's go back to this perfect bread. And I got hamburger buns now. And do you ever heard of sesame seeds on hamburger buns?
Yes.
Yeah, nice and decorative. You can chew through them, makes it more interesting. Suppose by mistake I put apple seeds on that bun. Oh my goodness, it's just delicious. And guess what? The bread lasts forever. So I want to sell, I know it's a bad choice because apple seeds are poisonous, but just bear with me. So I'm going to sell my apple seeded bread. Do you think that is something I should hold as a trade secret, or should I patent it first? What do you think? Gave you a harder question, didn't I?
Yeah.
Let me ask you a real simple question. As soon as I sell that bun with that apple seed on it, what are you going to say when you see that bun? What are you going to say about the seeds? Are you going to recognize them?
Probably, yes.
Heck yeah, it's apple seeds.
Yep.
That's not hard. If I presume I can hold that as a trade secret, I can't. You know immediately. It's apple seeds.
Yeah.
Okay. So that you probably want to patent, right?
hmm
Greatest bread in the world, because once it's there, everybody knows what, reverse engineer it, just look at it, right? Okay, that's it. And I thought Luke did a super good job. There's a tough decisions for companies getting started. Most people want a patent so they can put it on the wall and they can advertise it, but it might be a $20,000 exercise that doesn't yield them much. Okay, so you go through an analysis and you make a decision, financially and otherwise, what's best for your company. That's it.
I've got one question to throw over to the brain trust here. Can you talk a little bit about the consideration of patent versus trade secrets in developing software or applications of some kind, phone apps or things like that? This is something we see a lot, with new things being
Yeah.
developed, and everybody and their brother seems to rip off every other company in the space. So if you want to comment on that, I think that'd be helpful.
That's a really good question and a really difficult area. So software in general is an awkward fit for intellectual property protection. And it most naturally fits into a copyrighted work, if you would believe that, a creative work of authorship. And so what you can do with an app, and what we recommend any company that develops an app, we recommend they register their copyright in it. That gives you the sole right to reproduce it, make copies, and distribute it. That's good. But it is restricted to only that exact form, okay? So someone can still bring a similar app to the market, but they can't steal your code verbatim. I know it's tough. It's a tough area. But that is one means of enforcement. If you have something really creative and inventive in your software, so probably a specialized algorithm that does something that other software doesn't, right? So it's not just developing an app, it's some feature of your code that is really creative. You can apply for a patent on that feature of the code. That's a harder route, but it is done. So the most basic thing is, and it's so cheap, is register your copyright in it. It's $45. And then if you register early enough, do you happen to know, Luke, if you register your copyright within 90 days of publication or prior to an infringement, do you know what kind of damages you can claim?
It'd be statutory damages, and you could get up to, I believe, $30,000 per infringement.
Yeah. And if you put copyright notice on there and people had reason to know it was copyrighted and they still stole it, now you can claim up to $150,000. So you get somebody's attention. Yeah. It's a great question. Great question.
I appreciate the insights on it. I think it comes up quite a bit. Were there any other questions for Doug and Luke? Well, we thank you all for joining us in class today. Luke, tremendous job on wading through a topic that not everybody thinks about on a daily basis, or really dives into, from a business perspective. And Doug, thanks for joining us and helping organize this session. You are going to be coming back. I don't remember the date exactly. We're going to be talking a little bit more about entities, and I posted the link to the Seed Clinic website in the meeting chat, so students can check some things out. Our last question before you all go: What's the process look like if a student is going to request services? What does that workflow look like? I know, Doug, you said it goes to your inbox, but what happens after you make the first contact?
Yeah, that's a good question. So, I read the message, and the first thing I do is see if the legal assistance that's being asked for fits in our mission. There's certain things we can't do. We can't do disputes and litigation. We can't give tax advice. But as long as it fits within, the formation of a new business and related contractual work, then it's good enough. So I will contact everybody that submits a request through that link. And, I'm hopeful most of the time we can set up an appointment with a student like Luke. Might take us a week or two to do it. And we have an initial consultation, which is a Teams meeting, just like this. Nobody has to travel and park. And, we'll talk through what your legal needs are and whether we can be of service. And most of the time we can. And most of the time, as a Northeast Ohio College student, doesn't cost you anything to use our services. The, kind of the qualifiers are between semesters, the clinic's down. And as the semester changes, we get new students. If you're used to working with Luke, we'll have to find somebody equally as good looking and articulate in the next class. And, that's a tall order. But, that's just the way it is with the clinic. So we'd be happy to help.